emphasize that extremism in the defense of liberty is no vice.
You won't settle for putting Susan B. Anthony on the new dollar.
I think you have no jurisdiction to make that concession, Mrs. Ginsburg.
Welcome to Beyond a Reasonable Docket, a Liberty Justice Center production where we talk about what's going on in the legal world and how it affects your civil rights. I'm Ryan Morrison, a senior attorney at the Liberty Justice Center, and with me is Reilly Stevens.
Good to be here.
And Brendan Philbin.
Hey, Ryan. Nice to be with you.
Who are also senior attorneys at the Liberty Justice Center. This month's docket is a special trip to Motown, where we will recap the civil rights decisions from the court's recently concluded term. We'll update you on the cases we discussed before there was a decision, and we'll talk about civil rights cases that we haven't mentioned yet. But before we cover all that, Brendan is going to lead off a Supreme Court case ripped from the headlines, a discussion about the Fifth Amendment right to remain silent and presidential pardons, which of course is inspired by Dr. Anthony Fauci's recent trip to Congress. So Brendan, with a pardon in his pocket, should Dr. Fauci be able to plead the Fifth like Dave Chappelle?
In a typical lawyer answer, we'll say maybe. So just to catch our listeners up to date or remind them, back on July 29th, Dr. Anthony Fauci, a.k.a. America's Doctor, testified in his GAC, the Senate Homeland Security Government Affairs Committee, regarding his time as head of NIAID. And he answered every question over 100 times with exercising his Fifth Amendment right against self-incrimination. So even down to, they asked him what color tie was he wearing, and he pled the Fifth on that, or what color was the carpet in front of him. He pled the Fifth on that. So I was listening to this, and I was enjoying the comeuppance of Dr. Fauci, and Senator Hawley said something that got my kind of like nerd lawyer radar going. And he was growing flustered with the upteenth time that Fauci was exercising his Fifth Amendment rights. And Hawley said, Dr. Fauci, you can't claim the Fifth Amendment right because you've been pardoned. And then he said, it's been clear for a century or more. And then he cited the Supreme Court case, Brown versus Walker from 1896. And, you know, as great as our fine legislative branches, when they say something is clear, you have to view that with skepticism. So I did dive into what he's talking about, what's Brown versus Walker, and if it was that clear, did Fauci get bad advice from his counsel, or is counsel asleep at the wheel and just making this up? And so the answer to all that is it's not as clear as Senator Hawley says it is.
Imagine that. Of course, Fauci had like a small army of lawyers with him. What do you have, like 2 or 3? I guess they're with him, and they actually got to argue with the committee, didn't they?
Well, he had one too many, because one of them, they were supposed to sit in the row behind him, but one sat at the table and was unceremoniously removed by Senator Paul because the lawyer kept interrupting and he was not recognized.
Well, I'll stop being the interrupting lawyer and shut up and let you tell us about this.
No,
case.
This is good. This is why the people tune in. Is this just
go
banter?
Ahead. Tell us about it.
All right. So just on President Biden's last day in office, he gave Fauci a preemptive pardon against any offenses that Fauci may have committed against the United States from January 1, 2014 through January 19th, 2025.
Now, in and of itself, is that unprecedented, getting a preemptive pardon when you haven't been charged with anything yet?
Yeah, I believe so. Yeah, I can't recall any of it. There ever being
Nixon.
Other preemptive pardons. Maybe Reilly can. He's
Nixon. Richard Milhouse Nixon.
That's right. Yeah, Ford pardoned him. He hadn't been charged with anything. Very good. Thank you, Reilly.
So is it clear, can a witness plead the Fifth after he's been pardoned? So I think first it would help to just discuss kind of what is the Fifth Amendment. And there's this case, Hoffman v. United States, back in 1951, where this grand jury witness refused to answer questions about his current occupation. He pled the Fifth. He said, I don't want to incriminate myself. I'm exercising my Fifth Amendment right against self-incrimination. I'm not answering your grand jury question about what do I do for my current occupation. And so he was held in contempt. And this went all the way up to the Supreme Court. And the Supreme Court said the Fifth Amendment does not just cover direct answers that may directly incriminate you. Instead, it has a broader applicability, and it addresses statements that could be used as a link in the chain to eventually get to your criminal activity. So any evidentiary links that you could fill in by answering, you could exercise your Fifth Amendment right over. So it's broader than people think. It's not just did you do the crime? Oh, yes or no question, Fifth Amendment right. It's broader than that. But is it as broad enough as Fauci is claiming, saying that he can't even answer what color tie he was wearing? So the case that Senator Hawley cited was this Brown versus Walker. And as a guy who grew up in northeastern Pennsylvania, coal country, I love this because it's about coal. And my great grandson of Irish coal miners, I like when this is back in the news. So the auditor of the Allegheny Railway Company was called to testify for alleged violations that the railroad committed for basically charging too much for coal freight that it was hauling in violation of the Interstate Commerce Act. And during this investigation, there was statutory there was basically like statutory immunity for anyone testifying at the committee. And the auditor said, "Oh man, look, like this is going to make me look really bad. Like I'm a bad accountant if I'm letting this railway company overcharge in violation of federal law for the coal they're hauling from Pittsburgh to upstate New York." And I think the term he used in argument was like, this is a personal disgrace for me. So even if I have immunity for whatever crimes I may have committed, I still don't want to testify because it's going to make me look bad as a bean counter. And the Supreme Court said no, that does not cover your personal disgrace is not covered under the Fifth Amendment. So the language from that is it's a necessary corollary that if the witness has already received a pardon, he can no longer set up his privilege since he stands with respect to such offense as it has never been committed. So that's like 1896 Supreme Court diction. So it's basically like, hey, there's no more crime because you've been pardoned, so you don't have you can't use the Fifth Amendment.
So it kind of works a lot like getting a grant of immunity then in exchange for your testimony.
Right. Yeah, exactly. So that's all the way back in 1894. So we could be suspicious of that, right? Because that's a long time ago. But come in the 50s, there is another congressional investigation, this time a little sexier than coal, Soviet spying, right? This dude, this is Ullman versus United States back in 1956. He again had the statutory immunity to testify, and he again exercised his Fifth Amendment right. This time, a little more legitimate argument than the auditor back in 1896 for the railway company. This guy said, hey, look, man, this is the mid-50s. If I have to testify that I'm a communist, nobody's giving me a job anymore. So I'm going to exercise my Fifth Amendment rights across the board, regardless of what happened. And whether I had contact with KGB agents or not, doesn't matter. I'm not answering any of your questions because I don't want to be labeled a communist because I'll never work again in this country. So the court said, again, we're gonna reaffirm Brown v. Walker, and your Fifth Amendment does not cover personal disgrace, nor does it cover this idea that you may not get a job because you're a communist. It's only for crimes that could be linked to you through your testimony. So since you have this statutory immunity for this commission, go ahead and you have to testify. And so that is kind of the stage that Senator Hawley was setting, and it is relatively clear, right? So we have to ask ourselves, what was Fauci doing? And I think he kind of gave it away a little bit when, in his opening remarks, the only thing he did say is he accused Senator Rand Paul of having an unhinged obsession aimed at securing his prosecution. And so I think, I'm not on his legal team, thankfully, but I think this is more about potential state law prosecutions, because federal pardons are only for federal crimes. So if there are potential state criminal claims that could be brought, his Fauci's pardon wouldn't cover those. So he is kind of preventing those, cutting those off at the knees as far as his testimony goes.
Yeah, and I think that's an important distinction, because he was always back in COVID quick to say, I didn't order any of the schools closed. I didn't order any of the nursing homes, the people go from the hospital back to the nursing homes. I don't have the power to do all that. Yeah, but the people that did have the power took his advice and made their decisions based on what he said. So if he was contradicting himself, then you're right. Maybe the states could come up with some kind of argument, like some kind of fraud on the government, or some kind of other kind of trouble they can make.
Right. And keep in mind, the other potential avenue of prosecution is that his pardon expired, or was only for conduct that ended in January 2025. So any new crimes now on the federal level wouldn't be covered by that pardon. So, of course, lying to Congress has been a crime du jour. It seems like for the past decade, no matter what party's in office, we're always trying to get people who have lied to Congress. So potentially, if there's a lot of gotcha questioning going on, perhaps Fauci would also be concerned that he would lie to Congress. So that's the other potential criminal exposure he would have in that sense.
Well, I never heard if anybody on the committee wanted to have him held in contempt for not answering, based on the theory that he should have, because with his pardon and everything. Was there any indication of that?
I think it's being discussed right now. I'm not sure. I didn't see any like news headlines, but it's I'm sure they're out there if we could find them.
Well, I mean, Congress can give him immunity, right? I mean, if Hawley means what he says, that the pardon already prevents them from charging him with anything, then Congress can immunize his testimony, and force him to testify. Now, the trick with that is then he's immune, including from anything he says, right? And so, we were talking about some other famous Americans previously. There's another guy named Oliver North, who some people might remember. And the reason his conviction for the Iran-Contra stuff got overturned was because the D.C. Circuit ruled that the witnesses might have relied on his immunized congressional testimony, even though the prosecutors had actually been sequestered and unable to witness it, on the theory that, look, if the prosecutor hears it, then they can come up with some evidence based on that, even if it's not quoting from the testimony. Courts are very protective of that.
Yeah, and that those two Supreme Court cases that are at the heart of this both did that. Statutory, there was Act of Congress, statutory immunity, so those people were able to testify. And I think if the goal of this, more importantly, I think for the Republic, is learning lessons from the massive insanity that happened during that time. And look, Fauci is the guy who was doing it all, pretty much. So it would be great to learn and have lessons learned from that. And I think maybe that immunity that Reilly talked about would be a good way to go forward.
Well, except maybe what they're trying to do is they're trying to get him in a perjury trap, and so they're not going to want to do that.
Right.
Then you got immunity, he could just lie, and that'd be that. But I'm with Brendan. It'd be really nice to know the truth from everything that happened back in 2020, and even before that, because his journal talked about stuff like before in 2019 stuff was going on. They were learning from China. And figure out what was going on. But we don't want to get too far into it. But I'm kind of with Jon Stewart. Like, if there was a chocolate syrup outbreak in Hershey, Pennsylvania, I think I know where I would look first see where the chocolate came from.
Yeah, absolutely.
We discussed two cases earlier this year that did not have a decision at the time we talked about them. Those were the birthright citizenship and trans athlete cases. And Reilly, our predictive powers were pretty good on those cases.
Well, yeah, certainly when it comes to the birthright citizenship, it was pretty much as expected. So Trump versus Barbara is the name of the case, and the majority opinion from the Chief Justice basically holds that birthright citizenship is the constitutional rule under the 14th Amendment, and therefore, the way we have done this for 150 years, and arguably, there's a lot of discussion of history in these papers, going back much further, back to English common law, is the rule. And his opinion, as with the opinion we got in our tariff case, it's about 20 odd pages. It's pretty short and sweet. It's pretty to the point, and pretty much clearly says this has been the rule. This was the understanding of the rule. This has been the rule going back to English common law. All the things that the traditional defenders of birthright citizenship pointed out in terms of precedent and history, the chief and the majority pretty wholeheartedly endorses that.
Yeah, but there was like over 100 pages written down. So what was everything else about?
Well, but everything else is there's concurrences and dissents, right? So, for instance, Justice Kavanaugh, he is technically in the majority in that he voted to invalidate the executive order. That is, technically what is at issue here is the president's executive order declaring that birthright citizenship is no longer the rule, and the accompanying policies that come from the agencies due to that executive order. Kavanaugh would have held that it violated the statute, basically that the Congress in the Immigration and Nationality Act pulls some language in from the 14th Amendment. And it's pretty clear that what they meant by that is birthright citizenship as understood. And so Kavanaugh's position is that Congress already answered this by statute, and that makes the administration's policy illegal. He does not agree with the historical analysis. His view is that these categories, which we talked about, people can go back to the prior episode, of exemption, things like the children of diplomats, members of Indian tribes, that we can thematically look at those, and based on the principles by which those people were denied birthright citizenship, he would also deny it to the children of illegal immigrants, right? So that's Kavanaugh's gloss on the history, as he thinks you treat the history thematically, right, and that it is not the group of categories that they were thinking of at the time, is not the exclusive group of categories. Thomas takes. Go ahead.
Just real quick for our non-lawyers out there, Kavanaugh was in the majority, and it is a 6-5 decision because he agreed, he concurred at least in the judgment, which means he concurred in the outcome, like the final decision of it all. And he also, just for the non-lawyers out there, if you read the various amendments to the Constitution, the last clause, a lot of them has a little phrase in there that says, and Congress shall have the power to enact legislation to carry out what this amendment's trying to do. So he was basically saying with this act, they were trying to carry out the citizenship clause of the 14th Amendment.
Correct. Yes, and so there's lots of details of the history of how the English did it and what this treatise says or that treatise said. The rule that the Chief Justice put down for the majority is very much that birthright citizenship, as it's been practiced, is the constitutional rule, and if you want to change that, you need a constitutional amendment. Is the ultimate punchline of the case.
And I guess the disagreement gets with Kavanaugh saying Congress could change the rule by statute. But this comes out correct because Congress did write a statute, and so. But then the dissenters, they disagreed about history. I think, isn't that what Justice Thomas did?
Well, so Justice Thomas takes issue with the historical analysis and draws on a lot of these other principles and tries to endorse a different understanding of the history, which doesn't really hold up to my eyes. But this goes back to what we mean by jurisdiction, what we mean by they want to introduce this concept of allegiance. Again, people can go back and listen to our prior episode where we get into some more of the details of this. But the truth, but the chief and the majority, they look at Wong-Kim-Ark, which is a Supreme Court case that held that there was birthright citizenship, at least for the children of legal residents. And they followed that logic to its conclusion. And find that this is how it was understood at the time and what and how it has always been done since then, which, of course, there's also significant reliance interests when you're talking about people's citizenship. If they have citizenship here and nowhere else, if you're saying they didn't validly get citizenship here, that creates all sorts of messes and complications and things. And so I don't think you are ever going to see a majority of this Supreme Court creating that big a mess, to be honest with you.
Indeed. They're turning like millions of people into Tom Hanks in one of his lesser-known great movies, The Terminal, if you ever saw that, where he was a man from a fictitious Eastern European country, and while he was in the air, there was a civil war, and his government was overthrown, and when he landed, his passport was invalid, and he couldn't leave. I think he was stuck in LaGuardia. It may have been JFK, but eventually, spoiler alert, peace was restored, and he got to go visit the last jazz musician that was one of his father's favorite and get his autograph. So all's well that ends well for Tom Hanks, as it usually does. As far as the other case goes, with the trans athlete case, our predictive powers were there saying, hey, based on the oral argument, we don't think the plaintiffs are going to win. And they didn't. I'll just read a little bit of summary here I got. It says, male athletes who identify as female challenge these laws in West Virginia and Idaho under Title IX and the Equal Protection Clause. The regulations implementing Title IX require schools provide equal athletic opportunity for members of both sexes. And Justice Kavanaugh looked at the term sex in Title IX and wrote, it cannot plausibly be interpreted to refer to anything other than biological sex. And in addition, Title IX expressly allows for separate teams for male and female students, quote, precisely because of the biological differences between the sexes. Neither Title IX nor its implementing regulations even hint at any exception, as the plaintiffs sought for males who identify as female and have taken drugs or hormones to nullify that advantage. And under the Equal Protection Clause, laws that classify by sex, as we discussed in our previous discussion, must be evaluated under intermediate scrutiny, which requires they be substantially related to achieving an important government objective. And the court held that by separating male and female sports and limiting the female sports to females, these laws make a sex-based classification that triggers intermediate scrutiny, and the undisputed proposition that biological males generally possess inherent physical advantages in sport, making ensuring safety and preserving fair competition important government objectives, and limiting female sports to females is substantially related to that. Interestingly, as far as the judgment goes, as we talked about a minute ago, I think it was 9-0. The three dissenters, the more liberal justices, wanted to reach some kind of standard for transgender people, and the majority didn't want to go there because they said they didn't have to, because either under rational basis or intermediate scrutiny, the law was going to pass. A lot of folks kind of thought, well, what's Justice Gorsuch going to say because of his employment discrimination case from Bostock? And, he thinks he took it head on. I think he kind of dodged it. He thought Bostock supports rather than undermines the court's conclusions in the transgender athletes' cases. Gorsuch distinguished the classification in these laws from discrimination because of transgender status. So anyway, the athletes, the challengers there, were unsuccessful in their attempt to compete in women's sports.
Yeah, no, the Title IX decision you said is pretty much unanimous. I mean, I don't think they were ever going to get very far with that. I think the more interesting thing for the future is less about the trans aspect of this and more about how the court is looking at what we call as applied challenges, right? Because it wasn't that, there was a claim in this case, not just that, they had a Title IX right, but they also said as applied under the Equal Protection Clause, they should be able to sue for essentially individual exemptions where they could show that as to a particular student athlete, there was not an issue because of they had undergone whatever transition treatments, that there was not a issue of competition or safety, that someone should be able to make that showing. And Kavanaugh kind of waves that away in kind of a paragraph that he just kind of says, we don't have to worry about that. I think that's a really interesting approach to as applied challenges and exemptions for people exercising their rights. We talk about things like Employment Division versus Smith and the religious exemptions this court has been very, very eager to recognize from various things. I don't know I think that paragraph might come back to bite them.
It could. And if you remember, in our last podcast, we talked about how the Justice Sotomayor, I think in particular, was open to this as applied challenges. But, people raised the complications that would bring about in sports, because would you have to do a blood test for each athlete that day to see what their hormone level was, to see if they had some kind of advantage in the race that day?
I think the assumption, though, is if you're doing the as applied challenge, the assumption is the burden is on the student athlete to show that they have, that they can make that evidentiary showing, right? So you're kind of assuming that was part of the as applied challenge.
Yeah. Well, for now, though, there is no Title IX claim for transgender athletes, and they kind of dodged it on whether or not there's an equal protection claim. But as you just said, Reilly, this is not going to go away. It'll come back again someday, and we'll have to see what happens then. Other cases we have not discussed yet have to do with guns in paradise. Hawaii is paradise on earth. Officials out there wanted to make it a gun-free paradise, so they held aloft their magic tiki torch and said, "By the power of aloha." But instead of turning into He-Man Kamehameha, they declared all guns were forbidden from private property unless the property owner gave you express permission to bring your gun inside. The Supreme Court said this was unconstitutional in a 6-3 decision written by Justice Alito. And he wrote, and I'll read from the opinion because it was really interesting, and I apologize if I go at length here. He talks about after Bruin, which was the Supreme Court case that struck down New York's gun permit law. Hawaii and 4 other states singled out in that decision flipped the default rule. The default rule was a common law opening up a private property to the general public implied a license to all persons to enter, meaning that no person is a trespasser by merely coming on the property unless the property owner had given due notice that such a person is banned. And that's at Hawaii flipped it. You had to be given due notice that your gun was welcome before you could come in the property, or you couldn't come on there. Hawaii generally prohibited licensed individuals from carrying a firearm, even if unloaded or inoperable, on private property of another. And it applied unless express authorization had been given by the owner, lessee, operator, manager of the property. So there had to be a sign out front that said "Guns welcome," like a welcome mat, and like a firearm instead of the firearm with the circle and a slash. I guess it would have just been a gun and a smiley face of some sort. I don't know. And so that's what was going on there. And you can imagine this would have some complications. And Justice Alito wrote, Hawaii's new default rule burdens those wishing to exercise their Second Amendment right. Some proprietors who do not themselves object to entry by carry permit holders may be reluctant to post a sign welcoming such individuals for fear of alienating other customers. So under Hawaii's new default rule, a proprietor in this category may only be willing to consent discreetly to the entry of permit holders who make the effort to ask them. And this arrangement imposes new burden on permit holders who will have to somehow obtain permission to carry a firearm on the property before stepping onto it. And he then did an interesting example from a case that he was concurring in back in 2016 about a woman with an abusive ex-boyfriend. He writes, to see what Hawaii's new default rule means in practice, consider its impact on a resident of Hawaii whose situation is like that of Jamie Catano, a young Boston woman who wanted to carry a weapon to defend herself from a violent ex-boyfriend, but was criminally prosecuted when she used non-lethal weapon to offend him off. He says, suppose our hypothetical young woman, after clearing all the hurdles needed to get a Hawaii gun permit, left her home on a weekday morning and carried her handgun or in her purse. And on the way to work, she intends to fill up her car at a gas station. During her lunch break, she plans to walk to a fast food restaurant and then buy some items at a large drugstore. And after work, she wants to pick up her clothes at a dry cleaner, then shop for groceries. Unless each of these establishments has posted a sign saying guns welcome or something to that effect, each visit could expose her to criminal liability. And he goes on here to talk about, just her pulling in the parking lot there and having her gun on him was breaking the law. And then, if she wanted to take it with her inside, she would have to find somebody who worked there that had the authority to give her permission at each and every place that she went to. And this is essentially nullifying her ability, her constitutional right to carry a gun in public for self-defense. And particularly if you know somebody's out there with a possibility to harm you, this is really problematic, having to get permission multiple times to take your gun places. So ultimately, the bottom line is the Supreme Court didn't like this, and they said Hawaii's law violated the Second Amendment, and they struck it down. Moving on, Brendan, can you tell us about the bank robbery, how the cops found the guy that did it, and how the Fourth Amendment is involved?
All right. So this is a case of basically the law that's been on the books since the 1960s, being applied to modern day technology. And we could unpack that. So this is a run-of-the-mill, old-school bank robbery stick-up down in the Richmond, Virginia area. And I actually have a personal, not with this bank robbery, but I do have personal experience kind of doing these warrants, and it is fascinating.
You have personal experience with bank robberies? What? Sorry?
No, not with bank robberies, but with getting these what are called geofence warrants. So basically what happens is there's a crime committed, in this case, this bank robbery, and law enforcement will call up Google and the cell providers, and they'll say, hey, give us all the people who were around the bank at this time, and we'll narrow it down. So you can imagine that sucks up a ton of data, and that of individuals, people going by. We had a case when I was at DHS. Somebody stole some federal government property from a facility that was right next to the highway, and they ended up getting a geofence warrant. And there were thousands of people, because it was a busy highway at rush hour, and everyone driving by with their phone are getting sucked up. So this is a huge issue for privacy advocates, the ability of law enforcement to get massive amounts of data on people just for doing good police work, right? Trying to find this bank robber. So the police, they got this geofence warrant, and they found Mr. Shattery, and they prosecuted him. But his defense attorneys challenged the warrant because it was basically overbroad under the Fourth Amendment. So in order to understand all this, we got to go back to the 60s and prior to around, I think, 1965. What is a search under the Fourth Amendment? It used to be trespass, old school trespass, government agents physically coming on to your property and searching. But then in the mid 60s, there's this guy named Mr. Katz out in California, and he was running a sports book for this is the Irish Mob in Boston. He was running numbers, basketball games and stuff for them. So he goes out to what our older listeners will remember as a phone booth. And he walks into the phone booth, and he closes the soundproof door, and he dials, and he sends his numbers back to the bookies in Boston. But the FBI was onto him because Mr. Katz did not have good OPSEC, and he kept using the same phone booth over and over and over again. And they said they put a listening device on the wire on top of the phone booth, and Mr. Katz was prosecuted, and they thought it was going to be an easy day because they said, "Hey, look, this isn't a search because we didn't trespass anywhere. We had it on public property on this wire." But the court changed the game in Fourth Amendment in Katz v. United States, and it created a whole new test, and that test revolves around the reasonable expectation of privacy.
So did they get any audio off of him just saying numbers, or was it like the pushing of the buttons is what it was recording?
It was a listening device. So they got him saying Cal Berkeley -4 for 5 times or whatever.
Or the Celtics.
For the home team, for Whitey Bulger and that crew. Anyway, so the court came up with this Katz test, and it involves a search is a government intrusion into a space where an individual has a reasonable expectation of privacy. And so what is a reasonable expectation of privacy? It's two. It's subjective and objective. So one is we, as a society, have to recognize that the expectation of privacy is reasonable. So in the cat's case, yeah, of course, because that's why we have phone booths, right? We have people have the ability to close and be shut off, so that society recognizes that your phone conversations in a phone booth, you have expectation of privacy. And then did the individual exhibit that? And in cats, yes, he did, because cats, he closed the door and he shut himself off. So that is a search. So fast forward now, there's no more phone booths. Now there's cell phones. And so does a person like this bank robber and millions of others, like all of our listeners, do you have a reasonable expectation of privacy in your location information that's beaming from your cell phone every second? And this is a very unsettled area of the law, because the technology is changing, and there is a balance, right? Because it's good for law enforcement to have these tools because we can catch bad guys. But at the same time, it
makes it easier for them to follow you around if they want to.
Yeah. And look, I can't exist in this world without giving my information to third parties. Like my entire life is in the cloud, right? And that's a third party provider. I can't even buy lunch some places in paying cash anymore. So I have to have a credit card transaction, and all that information, all my financial information goes up too. So that there's this exception to one area where individuals generally don't have a right to privacy is if they give their information to a third party, right? And so that makes sense in the old days, but now when we can't go about our daily lives without giving our information to third parties, it is an exception that tends to swallow the rule of the Fourth Amendment. So that's like what's at issue here in this search is did the bank robber have a reasonable expectation of privacy in the records held by the cell phone provider about his location? And the court said yes, which is big for privacy advocates and those of us who don't want the government following us around.
So that was the only issue alive in this case, right? It wasn't whether or not the search was good or bad. It was like whether or not did he have that expectation of privacy.
Right. Yep. And so, yeah, people have a reasonable expectation of privacy in their records about their cell phone's location. So the geofence warrants are not per se unconstitutional. And the court didn't warrant them or didn't label them as general warrants, which I know Reilly worked on the LJC amicus for this. I think that was what we were pushing, right, Reilly, is that these are general warrants.
I mean, for the Fourth Amendment says that you have to get a warrant for the particular place and the particular things, right? The idea is, and we call this the particularity requirement, meaning they can't just come. Let's say they have evidence that you have a murder weapon in your underwear drawer. They can come look in your underwear drawer with that warrant. They can't go in your basement, at least in theory. And we could talk about, obviously, Brendan, you know better than I do probably all the different ways that gets complicated and the scopes of searches and these kinds of things. But in theory, you're supposed to have a particular thing you're searching for. And that is kind of the opposite of what they do with these warrants, where, we talked about bank robbers. This is also what they did to the January 6th people, is they got the coordinates of the Capitol building, and they ran which phones had Google location data to be in the building. That's how they tracked some of these people down. So that was actually a warrant that was thrown out by the judge in, I guess it was the Eastern District of Virginia, maybe.
Yeah.
Saying there is no particularity here. This is a dragnet, literally. You're just throwing out the net and seeing who you pick up. And that generally has been something the Fourth Amendment is frowned upon, right? So that has kind of been our angle on it that I've written about before, that there's no way to do this with any particularity.
Right. So that's, after this case, that's going to be the challenge for prosecutors, is because courts are going to be taking a lot closer eye at that particularity requirement of these warrants. So what does that mean in the in this cell phone context? It's like, how big is the geographic space that you're pulling information from? That aperture is going to close, because it used to be like, hey, anywhere in 4 square blocks from the bank, let's suck up all that information and take a look and see what kind of bad dudes are out there who could have robbed the bank.
We don't like this Black Lives Matter rally, or if you want to switch it, make it a Tea Party rally or a MAGA rally, pick your politics, right? Or the NRA convention or the Democratic Socialist American convention, you just pull every cell phone of everyone who was there.
Right.
Or everyone who's going to the Planned Parenthood or the gun store, right? Again, we can make it whatever politics you want, right?
To Reilly's point about particularity, this case is going to go back in courts, not just the Eastern District of Virginia, but now district courts and state trial courts throughout the country are going to be taking a lot closer look at the processes that are involved with this geofence warrants. They're going to take a look at how wide or narrow is the aperture for geographic searching, where before maybe law enforcement could get away with searching 4 blocks or 6 blocks around this bank that was robbed in Virginia. Now they're not. Then now they're going to have to close that and only search a narrower area. And the same goes with time, where you used to be able to maybe pull a couple hours on each end of the robbery or of the crime. Now they're going to tighten that aperture too. And then the third process that they're probably going to look at for particularity is this unmasking process. So these warrants are pretty technical. And the first round, your first ask as a law enforcement officer for give me all the phones within a 5-block radius of the bank between 1 p.m. and 4 p.m. And you're going to get a list, and it's not names and phone numbers. It's all anonymous, an anonymous list provided by the cell phone. And then from there, you narrow down which phones you want to look at. You kick that back over to the cell phone provider, and then they give you the names and numbers, and then you can go about doing your police work.
And this all goes to the reasonableness of the search. Like the Supreme Court said, okay, this is a search, and the things you've been talking about is like the reasonableness of it. Are you looking for too many blocks? Are you looking for too much time? That kind of goes to the reasonableness.
Yeah. It's stay tuned for this. I think this is an area of certainly of the Fourth Amendment law that's been trying desperately to catch up with technology, like going back to the Carpenter v. United States case, where they put the law enforcement put a tracking device on someone's car. Yeah, and they were able to find out where this dude was driving 24/7. And the court said, well, I guess you don't have a reasonable expectation of privacy because you're out driving your car around on the public highway, but the court was really uncomfortable with how much data and how much that tells about someone.
Sure.
And so they came up with this mosaic theory that didn't really set a standard, but it said, hey, if you're getting all this little information and you're able to piece together something that eventually will rise to the level of a search because someone has a reasonable expectation of privacy that way. And that was before that iPhones were around then, but I think that was
back in 12. I think that case came out in 12 or something around thereabouts. And of course, the police argued back in that, well, we could just follow the guy around all the time. This saves us manpower and we can just track him. But then again, you could have a car outside the bank 24/7 too and watching it, see who's coming and going. And so technology is making Fourth Amendment law really tricky.
Yeah, and I think we're Reilly, is mosaic theory for the traffic cams that we have?
I don't know if we would call it the mosaic theory. Because that the court has not formally endorsed that as a theory. That's kind of a gloss that some people like Orrin Keir and others have put on what was said in Carpenter, what was said in Jones, et cetera. And so I don't know if I resist biting off everything that involves, because there's a whole bunch of different discourse around what that's supposed to mean. But the general sense that metadata, as we call it, and these small little pieces of information about you can be assembled to create a bigger picture. We all kind of understand this now. I think we all understand that. They can scrape our data and, they can target us with ads and do all these sorts of things. Well, the government can also do that too. The police can also do that too. and they can put together a really interesting picture of you. I don't know if you've ever tried to download your Facebook data or your Twitter data or anything like that. It's very interesting sometimes to see the things they've tagged you with, right? But these things can say, it's one thing to say, oh well, you're driving on a street. That was the old Fourth Amendment theory. You could be driving anywhere and you're in public. You don't really have a expectation of privacy when you're walking around in public. What we now understand is if they follow your car to, again, we talk about the Planned Parenthood clinic, we could talk about the NRA convention, you can make it whatever political angle you want, right? We have, Illinois is actually banned, where we're suing, they've banned the use of license plate data to track women traveling for abortions, which, if you think that's unrealistic, apparently in Texas, they've actually done this now with some people who were leaving the state to get an abortion. And so these things can draw these very comprehensive pictures of our lives, even if any individual element is not, and the court has been concerned with that. I don't know whether or not they want to, I don't know that they're going to officially endorse the mosaic theory if the law professors have thought it through, but I think that if the direction they're going is caring more and more about these aggregations of data.
Yeah, it's interesting to watch, and just how this test develops over time. I think prosecutors will get pretty smart at it, but it'll be interesting to watch.
All right. Well, I guess we'll leave it there for our special trip to Motown for this month. They are Reilly Stevens and Brendan Philbin. I'm Ryan Morrison. We're all with the Liberty Justice Center. Thank you for being with us today. Please subscribe to the Beyond a Reasonable Docket podcast and tell your friends to subscribe as well. We appreciate your 5-star ratings and your kind reviews. They are a big help to us. Follow the Liberty Justice Center on all social media platforms, and come visit our home on the web, libertyjusticecenter.org, where you can sign up for the Beyond a Reasonable Docket Substack. We hope you had a great time with us today, and please join us again for the next Beyond a Reasonable Docket.
Court stands adjourned.